if you've been around for very long, you know that AAC-RMF traditionally has a model personnel policy that's comprehensive, that we offer up to the counties to use as a template, guideline, or you can just plagiarize the whole thing when you are considering updates or overhauling your county employment personnel policy. And this covers everything. This isn't just about medical marijuana or any one other issue. It's comprehensive. This year, traditionally we make it. This was originally mostly put together by Mike Rainwater and his team, and they're still heavily involved in it as they've always been. And over the years, they'd make a tweak and change one thing because some case would come down or some law would change or be enacted, and so we'd need to change one little thing or whatever, and you get an updated version. This year, we decided to take a hard look at the whole thing and overhaul and update it start to finish. And so that's what we've done. And the new 2017 version is much more new and revamped than the past years where we just tweaked one thing or one other thing. We took a close look at everything and updated anything that needed to be updated, added a lot, didn't really take anything out. And I thought I would just quickly run through the table of contents and kind of point you to the areas that are new or that have changed and just give you a quick overview of how this compares with the old one. Many of you may have counties where your personnel policy is essentially the old version of our model personnel policy. That would be awesome. We love that. And if your foreign court decides you want to take a look at it and update it, we would recommend you use this new version now. And by the way, you can email me. I'll send it to you in PDF. I'll send it to you in Word so that you can change the title, tweak what you want, and there you go, right? Real easy. I've got it in both forms. We're making this available to everybody like we always have, and we want you to follow it because this is what all of your risk management lawyers, Rainwater and AAC, these are the policies we want you to have to make sure that you're following the law and stay out of trouble. And even when somebody sues you anyway, we can win those cases for you because your policy's good, and if you followed it, you're probably okay. Let me just run through the table of contents, and I'll point you to things that have changed significantly or that are brand new, because if you want to look through this, you'll be able to know what to look for compared to what we were looking at before this year. The county employment policies section 3 there, has a lot of new stuff and a lot of updated stuff. The equal employment opportunity section has been updated to add a couple of new protected classes. These are classes that are protected by law. There's no choice in the matter. We've not added any that are not required to be protected classes under the law. You can certainly add to it if you want, but the list in there is just all the ones that you must consider protected classes under the law, and we added some language so that it automatically includes any new future protected classes if those are announced by the courts or by statute. So you really never have to change it. You could update it and add, or you don't even have to because it says any that are protected by law. The anti-harassment policy, 3D, is much more robust now. It's essentially the same, but there's more detail, there's more emphasis on how imperative it is that a person who feels that there's been harassment reports it and jumps through certain hoops and brings it to your attention so you can address it and all that stuff. Certainly in today's climate, this is, it's good to have a good anti-harassment policy. The genetic information non-discrimination policy is new. That's just required by federal law. None of you are taking people's DNA tests and discriminating based on the results, but it's good to have it in there. Political activity, that's new. There's an Arkansas law that prohibits public servants, which is all of you and everybody who works for a county or any level of government in Arkansas, from engaging in political activity while they're on the clock. Now, you're probably not going to get in trouble as the employer if an employee is caught doing that, but it's very nice of you to warn your employees that they shouldn't be doing that. It's rarely enforced, but it's a pretty clear law and a clear prohibition. You don't want your people politicking and campaigning on the clock anyway, so tell them on the front end that they can't do that, and we've got suggested language for how to address that. The social media policy section is new. This is a pretty standard social media policy. There's a little bit of wiggle room. We're not telling you got to go fire somebody just because you see that they liked something on Facebook at 2:12 p.m. on 3 months ago. So there's some flexibility, but you also don't want people sitting on social media all day and night. You certainly don't want them on there railing about you and their bosses and stuff like that. So there's some language about tempering your comments at any time about your employer, about the county, stuff like that. It's pretty standard. Freedom of Information Act added a section there. That's just to ensure that you comply well with the FOI. It just basically tells your employees, hey, if you get a FOIA request, you report that to your supervisor immediately so we can get on that 3-day clock, and take care of it. That's not required by law, but it's helpful because nobody wants to be caught having not properly responded to FOIA. And there's a little new language about county property, which is also very standard, just to, remind everybody that you don't own your desk and your computer and stuff like that. Under section 4, 4D, the background investigations language, if you choose to do background investigations on any employees, which you don't have to do, we'd recommend that you limit it to certain positions where it's actually relevant. It's a kind of a tricky area, and there's good language there that you can adopt if you want to put background investigations in your personnel policy. Not required, but if you do, be careful. Take a look at this language, and we recommend it. I saw Regina and John getting squirrely up here about drug testing and the Arkansas Medical Marijuana Amendment. The drug testing policy is largely the same as before. We do have updates from more recent federal regulations. Medical marijuana is in there. It is a grand total of 1 sentence that appears underneath and along with prescription drugs, because that's effectively what it will be if it actually becomes a reality in the summer of next year, which is the current prediction of when we'll go live. I agree with, I think I heard John saying, that you can, it's all about safety sensitive positions versus non-safety sensitive positions. I generally agree with that. If you only pay attention to it with regard to safety sensitive positions, generally you don't have to change much. Even if you have a card, in the future, if you're in a safety sensitive position, you can't be tested positive for marijuana. Or if that's prohibited, which everybody it is, then a positive drug test is treated the same as it would be today. But for non-safety sensitive positions, if somebody has a card in the future, we would recommend, first of all, you probably shouldn't be testing non-safety sensitive employees anyway. But if they turn up a positive drug test, you should not take adverse action based on that, assuming they have a card and all that. That's another thing I sensed from Regina and John was the truth, and it's my firm belief. If any lawyer or anybody stands in front of you and tells you they know all the ins and outs of how this is going to go down under the Arkansas Medical Marijuana Amendment, they are either lying or they are delusional, because nobody really knows all the answers about this. We're all guessing. We're all just trying to plan as well as we can and protect ourselves as well as we can. And the answers won't be made clear until people get sued and courts sort things out. And so you can ask me questions all day and night. I can tell you my answer is probably going to be, I don't know, nor can I see the future. And I'm going to refer back to the language in this policy and our baseline recommendation that you should focus on safety sensitive positions and not worry so much about it. Moving on down to the 5th section there, employee classification, attendance, and compensation. We've added some new opening sections about classifications, compensation, and attendance. This is just generic stuff. It's not something we're recommending to limit risk or anything like that. It's just that you're all going to put this sort of stuff in your policy anyway. And you should, it's nice for people to know what they're, the guidelines about this stuff. So this is just model language you can use as your template. Feel free to change the details about your business hours and stuff like that. To the extent we put any numbers in there, they were just to fill the gap. Those are totally flexible. We're not saying you need to change when you open or close or your attendance policies or anything like that. It's just, it seems kind of awkward to give you a model policy that doesn't address these topics, so we put them in there. Moving on to the second page of the table of contents. Same thing here with administrative leave and benefits. We've thrown in some generic language about insurance, holiday leave, vacation leave, sick leave, There's some variety on this stuff, county to county, employer to employer. This is just the starting place. You probably all have policies already that specify exactly how much of this and that leave you accrue per time and whether it's capped or not and all that stuff. Not saying you need to change any of that, it's just that if you're starting from scratch, we've at least already got sections in here so you don't completely forget it. You know, you remember to address this stuff, is the only reason it's in there. The FMLA leave section is largely the same. FMLA hasn't changed much over the years. It's a huge headache to comply with, and that's true for everybody. We're not uniquely miserable when it comes to complying with the FMLA. That's every employer nationwide. Thank you, Congress. Leave without pay, section F, that is new. Most employers do this now. Okay, so if you're going to, if you think there's a situation where somebody doesn't have enough leave time or whatever, it's not FMLA, they want to, I don't know, they've got to do something, they're going to be gone for a couple months, and you want them back, and you're going to say, okay, you can have leave without pay. That's totally fine, but put it in your policy so that you treat everybody the same. Because what you don't want is the next person to come up and ask for 2 months off unpaid for the exact same reason. You tell them no, and now you've got a lawsuit. So we've got model language about how to address leave without pay. Military leave and jury duty leave are new sections. They're required by law. Probably everybody was complying with them. Many of you probably already have sections on that, but if you don't, it's good to put it in your policy, and there's some model language. Now, both the informal procedure for reporting any sort of issues and the formal grievance hearing procedure, those have been in there for decades, I think. They're not really changed at all, okay? The last thing we want to do is change your grievance procedure when everybody's finally getting it right, you know? So there's no need to change it, and so carry on and follow your policies. The one new optional thing that is included here is under 8F, mediator role of the county judge. I stress this is totally optional. But if your county judge likes the idea, and some do, and it's in some policies now, you can have your county judge, you can insert a new phase in the formal process where the county judge serves as a mediator, and maybe the sides agree to resolve it, and that's it. It's over, your grievance committee doesn't have to make a formal decision, everybody's agreed to resolve it, it goes away. Now, you may have county judges who don't want to do that, and so it's totally optional, but we found that it's a really good tool to get these things resolved quicker and easier by agreement when you have a county judge who's interested in doing that. I mean, I suppose you could put it in your policy, the forum court could put it in the policy whether the county judge likes it or not, but I don't think that's generally how you guys operate. You probably would talk and figure it out first. Section 9 on grievance hearing issues and burdens of proof is no change. These are all just guidelines for the different types of claims that an employee may assert in a grievance to give you sort of the legal standards that govern for whatever it is they're claiming, however they were wronged. This is to help the grievance committee understand the framework and how to analyze the claim and whether it's valid or not. It's been in there in the past, we're keeping it. We think it's more useful than harmful. I mean, it somewhat gives somebody a template for how to make a successful complaint, but if they're full of it, we'll be okay anyway, and so we'd rather the committee understand the proper analysis so that we make correct decisions, even if we are providing a template. In the internet age, they can go find their template anyway, or they'll figure it out anyway, so not too worried about giving people the ammo, because we've got bigger ammo through our procedure. And the last thing there is just a catch-all, issues not addressed in the personnel policy. Just a little language that allows the county judge or the elected official to sort of issue memos or policy guidelines to fill gaps. If you got a situation that's not addressed in your personnel policy, this is the quorum court authorizing the elected officials to say, okay, well, here's how we're going to handle that, and do a memo, distribute it to your employers or whatever. And now you sort of attached an addendum to the personnel policy by virtue of this without having to go through the formal procedure of adopting a whole new policy. And I'm not going to go into the details of the actual policy. I'll let you all read those for yourselves. I'll let you bombard me with questions right now if you want to, or please feel free to reach out to me or Mike and his team at the Rainwater Firm. We all worked on this together. They've worked on it for years before. They're very expert on all this stuff, and I'm familiar with it now within the last 6 months. So don't guess. And I think the bottom line is it's better to have good policies than not. But of course, you need to make sure before you adopt anything that you actually can and will follow it. There are situations where it would be better not to have that in there if you're not going to follow it. It's probably better to be silent. But our hope is that, and experience shows us that this is stuff that county officials can follow without too much of a problem. Certainly the optional stuff. I mean, there's some stuff in there that's really difficult for everybody, and that's just the way it is because we have to do it, like FMLA. But the optional stuff, it's up to you. We recommend everything in here, and I had a whole bunch of other stuff that I had written up that we decided, nobody's going to want that anyway, or that's too complicated, or only Colin understands what that means, and so we just took all that stuff out and we culled it back down to something manageable. Hopefully, this is useful for you. Any questions?
What's your email address?
My email address is cjorgensen, that's CJORGENSEN, at arcounties.org.
Are these policies available in a digital format that we can copy and paste into our?
Yes, we don't have this on our website, but if you want to email me, I can send it back to you in PDF or Word or both. Absolutely. We would love, I love it when somebody asks for me in Word, like I already sent it to them in PDF, hey, can I get that in Word? To me, that means they're going to use something out of there, and that's good.